Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from INTERSENTIA. It's an important book. It's this one over here. I'm not sure what colour you would call it, purple or mauve, I don't know. But anyway, it's a big book, this one. We'll have a look at it in a minute. It's called Security Rights and the European Insolvency Regulation. It's been edited by two people, Gerard McCormack and Reinhard Bork, and as I say, it comes to us from INTERSENTIA, based in Antwerp and Cambridge, and it's part of their civil justice programme of the European Union. Now, Elizabeth wrote the main work, but we did have a long discussion about this book because of the contents and what it's really about, and we came up with a title for our review: Legal Rights over Property Across a Range of European Union Jurisdictions, and the UK too. So let's have a look at the book first of all. There it is. A nice little divider, which is quite helpful. But let's have a look at it first. It's a heavy book, it's a hardback. There is the front and there's the spine. There's nothing on the back. You can see the title there. If we go to the back first of all, it runs to 700 pages. The index at the back is by page numbering. And you've got quite a detailed index actually. It's very helpful to have that because there's a lot of information in it. What you've got is the various chapters, and with each chapter you've got numbering. It's not quite the same as paragraph numbering in the sense that we know it, but it's just general numbering. Now at the front, there's the front page there, and then we've got a disclaimer, which you can see there. It sets out very clearly what the book is all about here, and then it's got the various pieces of information about the actual people who've been involved in this, because this is being co-funded by the Civil Justice Programme of the European Union, and obviously is given financial support by the Civil Justice Programme, which is explained in the disclaimer there. In other words, it's not reflecting the views of the European Union. The preface is worth reading because here McCormack and Bork are trying to set out exactly what the purpose of this book is, because it didn't initially flow quite the way I'd wanted it to. I think mainly because there's been a certain amount of translation going on. There's the content section. This book's an important book, make no mistake. You can see the various chapters. There aren't that many chapters. There are a total of 8, I think. Yes, 8 chapters in total. It's split into 2 parts. One is, the first part is comparative analysis and then national reports. Then there's a questionnaire that was created, which is worth looking at, so you've got some idea of the various questions that were asked. Then the cases. Obviously you've got the what was the ECJ, now the CJEU cases. You know the name has changed. And you've got various other cases. Then you've got the various cases by state, member state, and so forth. You can see those listed there. Then you've got a very useful one. There is actually one case from the United States, which you find interesting. Then you've got the table of abbreviations. Very, very helpful in this particular area because there are a lot of abbreviations and quite often it's difficult to know exactly what some of them stand for. As you can see, a lot of them they run through quite a substantial number of pages. And then we start off after that with part 1, which is the comparative analysis. Then there's an introduction. And you see the numbering. The numbering is just 1, 2, 3, 4. It's not 1.1 or anything like that. And then what you do have is you've obviously got quite a lot of footnoting all the way through. It's a heavy book, as I say. It runs to 900 pages, very nearly. Well, sorry, 700 pages, not 900. And then there's a list of people who've been involved, because there's more than just the 2 main editors. Obviously, other people whose names I haven't actually included on the in the written review, but they are Reinhard Bork, of course, who's mentioned, Marta Carballo Fidalgo, Laura Carballo Pinheiro, Renato Mangano, Gerald McCormack, and Tibor Tajti. If I pronounce those names correctly. As I've said, I think one of the reasons why initially we had some, not concerns, but some slight misunderstanding about what this book was really covering, which became apparent quite quickly, was because I think there's some translation that is not as easy as it might be. But when you get into the book, you realise what this is about, because the title, Security Rights and the European Insolvency Regulation, is of course about money, and that's really what this is about, if I can put it in its simplest terms. And we're talking about legal rights over property. Now, in England and Wales, we have charges on property. We have encumbrances on property. We have the Land Charges Act. We have a register. We have all sorts of things. But of course, it's different in other jurisdictions. Let me tell you a bit about the book, because I think it will be of interest to many people, because we are in a much more of a global community today. And people, of course, own property elsewhere and they have interests in other countries. Security rights, legal rights over property, we would be inclined to say in common law jurisdictions, which this book does cover, as well as other legal systems across the European Union. So it's not specific to common law. These, of course, include the following. The Germanic legal system, that's Austria and Germany. The Roman legal system, Spain, Italy and France. And the Central and Eastern European systems of Hungary, Poland and Lithuania. So you've got a real mishmash of different systems to consider. The book has arisen out of a research project funded by the European Commission under the Civil Justice Action Programme, which is mentioned in the disclaimer at the beginning. Although the disclaimer, which I mentioned, by both Gerard, McCormack and Reinhard Bork indicates that it should not be taken to reflect the views of the Commission. I think that's perfectly fair. In other words, it's not an official publication in that sense, but they've obviously given the money to fund it to produce this, what is a good work. It's an important work by INTERSENTIA. Now, as the authors explain, security rights are essentially rights over property intended to secure payment of a debt or other obligation. It doesn't matter where you are, those are basically that's the position at the moment that we have across the globe. Fundamentally important is the granting of credit, and are generally considered to increase the availability of credit and the lowering of its cost while conferring other benefits to debtors and the overall economy. And therefore, because it's the whole granting of credit is based upon this, you can see why the word security rights come into it, because that's actually what it's about. UK lawyers, we think, will be particularly interested in McCormack's report in the latter half of the book, because it's in two sections, as I've indicated. One is on security rights and insolvency in the common law system of England, as the legal traditions, of course, in both Scotland and Northern Ireland differ. And in pointing out, of course, the author does, that there is no universally recognised definition of security rights under the common law. So basically, they're creatures of statute, if you like. But he does go on to describe security in this context as generally signifying a right over property to ensure the payment of money or the performance of some other obligation, adding that the property over which security is taken is referred to as secured or collateralized, basically the same thing. But you can see again, it's like the concept of the charge on a property. It's basically similar. So, as I have found with many different jurisdictions, they use different words, but we end up with the same sort of thing at the end of all of it. And what we've been trying to do for a long time is to try to standardise a lot of this. And I still think we'll succeed, even though Britain's leaving Europe. Now, with this impressive volume, it's over 700 pages, there are a host of related issues which are discussed in the context of insolvency proceedings, affecting, for example, the debtor, amid suggestions for possible reform measures and an emphasis, which is not exclusive just to this book, on the need for further European harmonisation. And I suggest that that will come irrespective of Britain's decision to leave the EU, because it's a wider point than that. And we will still be needing to make our own international trade agreements, irrespective of our relationship with the European Union as it changes. Now, speaking of which, let me just say that there is a note of lament on the matter of Brexit. And you notice the book fell down when I said that. It must be a jinx. It looms ever closer. I'm recording this in the summer of 2017, and we are looking at the moment at leaving the European Union in March 2019. And it may, to use the expression, quote, cast a long shadow, say the authors, expressing the hope, that's Brexit, that these events do not dim unduly the prospect for further European scientific research and cooperation. And I will say right away that irrespective of what is happening, I don't see that there will be as much damage as people make it out to be. A lot of it's pure tribal politicking, frankly, but the bottom line is we'll be getting on and making the best of it. And that's what I intend to do, and I'm sure a lot of other people who voted Remain will take the same line. There's no good crying over spilt milk, we've got to get on with it. Let me conclude by saying this, and just to deal with Brexit and this, because there is an influence, but I don't think it should be taken out of proportion. Confident that the current negotiations on Brexit will result in a positive, or at least a reasonable outcome, comparative lawyers, and indeed any or all practitioners involved in property matters within the European Union, will more than likely be interested in acquiring a copy of this information-rich book, which is what it is. And it's a very useful new title from the Cambridge and Antwerp-based INTERSENTIA publishers. And I'd like to thank Tom Shears very much for sending it to me, because I think this is a very important book, which is why we've actually produced the review. The publication date, of course, is cited at 2017. Now, without knocking the book over, I'll just show you it again. There it is. I think this is, I don't know what colour this is, whether it's purple or what it is. I think it's probably a purple. There's the front anyway, and the side. Opening it up in the middle, you can see the structure. This is security rights and insolvency law in a common law system. This is national report, which is structure right in the middle. You see the numbering at the side, very similar, basic paragraph referencing numbers, and you've got a lot of footnoting. There's a lot of detail. I think it makes a very good. There's also a lot of useful case law, which I think probably gives you some flavour of the issues that arise, and going through it, security rights and insolvency law in the Roman legal system. So you see, what they've tried to do is to give very much the comparative systems a fair hearing, because we're looking at security rights, that is basically charges, if you understand my terminology in English law terms, charges and European insolvency regulations. They love their regulations, which is one of the reasons we're leaving. The fact of the matter is we have regulation, and we've got to have agreements. It's as simple as that. And the question is how much. It's really what the issue's always been about. Anyway, Brexit or no Brexit, this book's an excellent book, and if you are involved in this particular area of law, both in England and Wales or in the EU, this is a book you must have. Thank you to all, very much indeed, to the editors and to all the contributors for the work in producing it. Bye-bye.